My name is Jon Roland. I am the founder and president of the Constitution Society, whose offices are here in Austin, Texas. I'm here today to discuss solutions to our misgovernment, which afflicts so many people, but for which too few have developed specific solutions. The problems of government in this country are, in fact, remarkably well known. If you talk to people on the street, you will find a very extended awareness that there is a problem, and even some understanding of what it is, what causes it, but really little understanding of what to do about it. You can find numerous stories, not just from actual victims of injustice, but on television, in the movies, in novels, and numerous books describing our problems, and in a few cases, even hinting at solutions. But almost none of them offer specific solutions. And in the very few cases where it's anything like a specific solution, such as a piece of legislation, appears and gets any attention, that is almost always a bad idea. That would not, in fact, do what it claims it would do, but it more likely than not do the exact opposite. We have a problem in this situation of what is called controlled opposition. Vladimir Lenin once famously said, "We control the opposition by leading it." And I'm afraid that much of what passes for reform efforts in this country, signaled by the lack of specificity, is in fact an effort on the part of the establishment to divert the attention of would-be reformers to activities which cannot possibly be productive. You won't get that from me. I have tried to put together a comprehensive set of reform proposals. These are not just vague demands that somebody do something about this, that, or another. They are specific bills to be dropped into the hopper after being signed of the U.S. Congress. There are specific pleadings to be filed in court and orders for judges to sign. You do not win any victories by leaving the details to someone else. I learned a long time ago in litigating cases in court that you can win a case, but if you have not drafted the order for the judge to sign, he'll turn to your opponent and ask him to draft the order. And you can imagine how that's going to turn out. So everything, every reform, everything that needs to be done needs to be specifically spelled out, either by you or by someone who you trust to have done it right. And there are plenty of examples these days of proposals that have not been done right, that are designed to, lead people down a rabbit hole. They invariably sound appealing. They're exciting, they're simple, they're clear, and they're wrong. Real solutions are, in general, not any of those things. Real solutions are difficult, they're detailed, they require intense study, they require years of background research, planning, and execution of those plans. We are in a kind of war. It's not a shooting war for the most part, although there are cases of shooting. We are a war against the enemies of the Constitution. Most of them are not, in fact, evil people by their own lights. Most of them think of themselves as the good guys, trying to do what seems to them, by their lights, to be right. But they're not, because they don't really know what they're doing, even if their intentions were good. We are trying to manage a very, very complex system. Call it a polity, a society, a country, and its government. But these things are not simple. They require intense effort to understand. And to understand, we have to understand where we are, where we once were, and where we went wrong. And we didn't go wrong just at one point in time. There are more than 200 key Supreme Court precedents that represent departures from fidelity to the Constitution. It has taken 200 years to build that body of precedents, and it would probably take at least that long to roll them all back if you try to do it decision by decision. And that's not going to happen. The legal profession of lawyers and judges is an inbred culture that insists on following precedent, even though precedent is, strictly speaking, logically incompatible with having a written constitution of government. You are not going to break that culture simply by getting a few favorable court decisions, no matter what they might be. We're going to have to replace most judges and most lawyers. And you can't clean the barrel full of rotten apples just by replacing apples a few at a time. This is going to have to take a complete replacement. And it's going to take going all the way back to the way lawyers are taught in law school or even in public school. So we're looking at a process of at least 2 generations, probably at least 60 years, if we were to do it by litigation. I have concluded that there is no substitute for amendments to the Constitution. Not amendments that would change what the Constitution originally meant, but to clarify it. The Bill of Rights, the first 10 amendments to the Constitution, were clarifying amendments. Except for the $20 rule of the 8th Amendment, they did not add anything, 7th Amendment, they did not add anything to what was already in the original Constitution. All they did was clarify it, but those clarifications have proven to be critical. Even the Reconstruction amendments following the Civil War were, for the most part, clarifications of what was already understood by the framers when they wrote the original Constitution of 1787. The only thing the 14th Amendment did was add a power of Congress to enforce it. Judges may respect amendments if there is a strong enough constituency demanding compliance with them. It would take a much larger constituency to get them to roll back bad decisions, one decision at a time. And that is what most of the government abuses are based on. 90% of all the abuses being committed by government today are based on court precedents. Precedents that deviated from the Constitution as originally meant and understood. Yes, a lot of the problem can also be found in statutes. But most of the statutes that are abusive were also enabled by court precedents. The Patient Protection and Affordable Care Act could not have been passed, much less sustained, if it was not built upon a legacy of court decisions going back 200 years. It simply would not have happened. So we can replace all the judges, we can replace all the members of Congress and the state legislatures, the governors, all the key people in public office, except for we also have another problem. There are not enough people who are qualified and disposed to replace them. I probably personally know most of the, what I would consider true constitutional scholars in this country. Those who, in my opinion, for the most part, get it right, who know what the Constitution originally meant and understood. There are probably less than 200 of them in the country. That is not enough to come anywhere close to filling all the judicial positions that we would need to make vacant, much less all the positions in Congress, in state legislatures, in the executive offices of states, and even at the local level. If you tried to find someone now to run for a public office who really knows the Constitution, doesn't just pay lip service to it, you'll be hard-pressed to find such a person. And if you do, the chances are he can at most get a nomination from a third party and therefore have no chance to get elected or even to appear in public debates. People are not voting for constitutionalists. Constitutional compliance is not a leading issue in any political campaign. The people are not demanding it. And unless and until they demand it, nothing will change. The corruption of government begins with the corruption of the people. And until you correct the corruption of the people, you will not correct the corruption of government. Political corruption begins with every voter who votes his pocketbook instead of for what's good for the country. There is no difference between a politician who sells his vote for a donation and a voter who sells his vote for a promised government benefit. The establishment has been erected upon a base of dependency on government. Both major parties try to cultivate their own constituency base of dependence. There may be somewhat different kinds of dependence, but the dependence is real for both of them. The dependence takes many forms. You can't really put a percentage on it because it's a state of mind. People indicate their feeling of dependence by the way they vote, by the way they participate, and we can see from the way they vote and participate that dependency is very nearly universal. It's not just 47%, it's closer to 97%. And until that changes, until we learn to rely on ourselves, until we stop complaining and telling our stories with the implied request that someone come to our rescue, we will not get a solution. Nobody's coming to our rescue except ourselves. We have to do it ourselves. Reform begins with each and every one of us. And we have everything we need to achieve the result. We don't need a lot of resources. We have all the resources we need. We have numbers, we have money. Everything we need to achieve reform is within our grasp. What is missing is the understanding and the will. Now, I have a website where I have assembled a very large array of specific proposals. Proposals for amendments to the Constitution. Proposals for ordinary statutes. I have other lists of proposed litigation, of proposed ways of educating the public and leading them and organizing them. If you go to constitution.org and to my campaign site, jonroland.net/proposed_bills, you will find them nicely gathered together in a few simple lists that will nevertheless require a lot of study. Many people have said admiring things about my lists, but then went on to say things that indicated they didn't really understand. And you have to do more than just be impressed by a few words. You have to dig down to understand why everything I have written is written the way it is and not elsewise. When you really understand why they're written that way, then you'll understand the steps that have to be taken. It's not enough to dream of victory. You have to be able to imagine victory. When Pearl Harbor was attacked in 1942, we didn't just lodge a diplomatic protest. We didn't just call on some other nation to come to our rescue. We declared war. And then we planned to win that war. We marshaled the entire population, the resources, the people. We made plans. We built weapons. We set up supply lines. We developed military strategies, not just to win on one country, but in two entire continents. We invaded Europe and we invaded Asia. And we won. And it wasn't by simply throwing our forces at the enemy. It was by careful planning and careful execution of plans that, yes, though they might not survive contact with the enemy, were being executed by people who could replan and replan from 1 minute to the next, but always proceeding with a plan. And the old saying is true: those who fail to plan, plan to fail. Before we can achieve the promised land of constitutional compliance, we all have to try to imagine what it would look like, how it would work, in detail, answering the questions of who, what, how, when, where, why. That is establishing all the powers, duties, for structure, procedures, everything that was needed to engineer a comprehensive solution. And then we have to step back and figure out, how do we get from here to there, step by step by step. Hundreds of steps, thousands of steps, millions of steps, involving literally millions of people. Our situation does not admit of small thinking. It is easy for people who have been abused by the system to come to dwell on their own cases. I've had a few of my own, but I don't dwell on my cases. I've used them as learning experiences, and they've been great learning experiences. Expensive learning experiences, but great. And on the basis of those learning experiences, I have tried to erect a complete and total solution to every aspect of the problem. And you can find it on my websites. I'm available to help anyone who is willing to work toward the ultimate solution. And it will take work, and it will take smart work. It will take working day after day, month after month, year after year. This is not something that can be done a couple of hours a week. You're going to have to dedicate your lives to it, as I have done in founding the Constitution Society and conducting its operations. We need many more people to do that. I need to be joined by hundreds, thousands, tens of thousands, hundreds of thousands of people, all as dedicated as I try to be. And it is only by doing that that we have any chance of achieving something that we as human beings deserve if we will but claim it for ourselves. Thank you.
Good job. All right, we still got plenty of time to talk.
Okay.
All right. You want to talk now about some of the specific ideas that you have?
All right.
Let's do that. Stand by.
I'd like now to turn to some of the specific pieces of legislation to be found on my website. First of all, the amendments. I have tried to write amendments that are clear, concise, and succinct, but carefully written to overturn almost all the bad precedents that have occurred over 200 years. And writing such amendments is a craft that is not taught in the law schools. These amendments fall into three categories, and there are three bills, one for each category. The first are clarifying amendments. The second are remedial amendments. The remedial amendments are amendments that supply a deficit in the original Constitution that the founders would probably have included if they had thought about it, but they didn't think about it. Then finally, the substantive amendments are the actual changes that in most cases fulfill the vision of the framers, but with much greater detail. These are not a few amendments. They would more than quadruple the length of the Constitution. But one of the things that one learns in law in moving from a simple contract through litigation is that eventually you have to write much longer contracts with many more provisions that are designed to withstand the efforts of clever lawyers to distort them. One of the principles of constitutional design is you must always anticipate how an opponent is going to twist the words. And plan against that twisting. It has to be so clear and cover so many bases that there is no wiggle room left for a clever lawyer. And that is a high art. Among the clarifying amendments are a clarification of the commerce and necessary and proper clauses. These are the clauses upon which have been based most of federal criminal legislation that has been adopted for the last 60 years. Most of it is based upon two key precedents, one going all the way back to 1819, McCullough v. Maryland, which weakened the necessary and proper clause to allow for Congress to pass anything that was convenient, not just what was necessary. And the second on the 1942 case of Wickard v. Filburn, which allowed the government to criminally prosecute someone for growing his own wheat for his own use. Believe it or not, most federal criminal statutes passed since 1942 cite Wickard v. Filburn for their authority, and not the Constitution. Probably 95% of all prisoners in federal prisons today are held unconstitutionally, because although there may have been a crime under state law, there could be no crime under federal law because there is no constitutional authority to make what was done a crime. And yet juries, in their ignorance, typically find defendants guilty anyway, because they are not taught in the schools to really understand the Constitution as they once were in the 19th century. That needs to change. The jury is one of the key elements for needed reform. And if the jury pool doesn't know how to play the role of juror, then we are not going to get solutions from jury nullification. And we need to. That begins with such reforms as requiring that all legal argument be made in the presence of the jury, as it once was when this country was founded. Today, everyone takes for granted that legal argument is made outside the hearing of the jury. The jury never even knows, in most cases, what the rulings of the judge are in the motions of law made before it. All they are asked to do is to decide whether, in a criminal case, the defendant did it. They are not asked to decide whether what he did is a crime, whether there's any authority to make it a crime, or whether his rights have been violated by the judge, the prosecutor, the investigating or arresting officers, or by anyone else involved in the case. That evidence and that argument is hidden from them, and they cannot render a valid verdict without it. We have the problem of immunity of public officials. That's not part of the original Constitution either. That immunity was erected by a long series of court precedents. And one of the things those court precedents did was deny the right originally held by all persons to prosecute a criminal case in court. Originally, any person could take a complaint to a grand jury and be appointed prosecutor in that case by having the grand jury hand the bill of indictment to the complainant. Now, the complainant would typically be a lawyer or have a lawyer working for him, but even if he were not a lawyer, even if he were only read in the law, he would thereby be authorized to appear in court to prosecute the case. And that is the only way that cases are ever going to be prosecuted against public officials themselves, because they have formed themselves into a tribe. It is them against non-tribe members, and those non-tribe members are the rest of us. It is us against them, and that is the way they see it. They circle the wagons against us Indians when we threaten to deprive them of their favored positions. But unless and until outsiders can intervene in the system, we will not get justice. As one lawyer once said in the corridor of a courthouse in Comal County, Texas, speaking of his fellow lawyers, we own the courts and we make the rules. And that is the attitude of too many lawyers today. We, the people, exist only as their cattle, to provide them with milk and meat, to keep them comfortable, for them to prey upon us. And the situation is not going to improve until we can change that. But we're not going to overturn bad precedents just by a few court decisions. Yes, the misinterpretation of the necessary and proper clause was reined in slightly in the recent Supreme Court decision on the Health Care Act. But then one judge went on to create a whole new precedent recognizing the individual mandate as a tax, which no one else thought was valid. And yet now it's established as a precedent. And a precedent not just for federal lawmakers, but for state lawmakers. Because now anyone at any level of government contemplating legislation can look at that precedent and say, okay, we are authorized to impose a tax on not doing something. Never before in history was it ever contemplated that there could be a tax on not doing something. That was inconceivable until this one decision. And now the floodgates are open, and I predict we're going to see a lot of new tax legislation premised on taxes for not doing something. And that could mean the unraveling of what few rights we have left. My proposed amendments deal with this kind of misinterpretation systematically. It goes through the entire Constitution, all of the provisions of it that have been misinterpreted, and corrects the misinterpretations, leaving little room for ambiguity. And removing ambiguity in a few words is not easy. Those words are chosen very carefully. But I can't say that I have not overlooked something. I need people to go over my proposals thoroughly and to find them ways, if they can, that I have overlooked something, and propose further changes to them so that if and when they are ever actually introduced, we have closed all the holes that the moles can appear out of, mole heads can appear out of. If you leave one hole unclosed, they're going to find a way out. So, what's a substantive amendment? Well, simply requiring all legal arguments to be made to a jury. It's technically clarifying, but it needs to be supplemented with additional material to make sure that it actually happens. Now, this is mated with another bill, which I call the Civil Rights Act. Now, most people think of the Civil Rights Act as something to protect some minorities. Well, we're all minorities now. The original intent of the 14th Amendment was to extend the jurisdiction of federal courts to protect all of the rights in the Constitution in cases where between a citizen and his own state. But then Congress started passing legislation identifying particular rights for special attention. And what the courts started doing with that is they stopped recognizing rights that were not mentioned in legislation. So what my bill does is builds upon the example of this legislation that names rights by naming almost every right you can imagine. Hundreds of them. It goes through the entire history of Anglo-American jurisprudence, back 800 years, to everything that was ever recognized as a right, puts it into modern language and spells it out. And of course at the end it has a catch-all for and everything else we haven't listed above. So it does what was not done by the 9th Amendment. The 9th Amendment was a catch-all for the first 8 amendments. They felt that they couldn't list all the rights or even many more of them, so essentially they referred back to history, known to the legally educated people at the time, but not known to people today, even the legal educated ones. Today, a judge looks at the 9th Amendment and says, well, there's no right spelled out, so I can't do anything with this. Instead of looking back to history and to the cases and commentaries of the judges and legal scholars that were the authorities for the Constitution, they simply dismiss it out of hand. Well, I spell it all out. And it can be interesting simply to read the list, to go through them one by one by one, and realize just how much there is that does need to be spelled out. This is, as far as I know, the first attempt, comparable attempt, to provide a comprehensive listing of our rights in one document. And it should be studied, if only for that reason. Now, we need to address our nation's debt crisis as well. Not only this nation, but all the nations of the world, largely following our example, have built economies on debt instruments, starting with money, fiat currency, which is backed by nothing but debt instruments, but augmented by the debts of governments, of private individuals, of corporations, of banks. Everybody owes money to everybody else, and the money is not backed by anything. speculators play games with that currency. And that's really what they're doing. They are making bets on debts, on bets. And ultimately, they have built and erected a mountain of debt that can never be paid off. It's not just the 16 trillion of national debt of the United States. It's probably well over probably 40 or 50 trillion worldwide. That debt will never be repaid. The only way it could be repaid is by inflating currency, by printing more money. And that would collapse the world economy. It cannot be repaid by raising taxes. It cannot be repaid by cutting spending. It cannot be paid by growing the economy faster. The U.S. economy and the world economy has never sustained an annual growth rate of greater than about 2.9%. Some politicians today are calling for raising that to 5%. It would have to be more than 100%. It will never happen. It cannot be done. Eventually, the whole thing comes crashing down. So I have developed solutions. Some of them are pretty radical, frankly, for dealing with this problem. You cannot stop people from speculating. If they're going to invest, they're going to speculate. And it does not work to employ an army of regulators trying to impose rules, play cat and mouse with people engaged in such speculation. They can never gain effective control over that process because they don't understand it. The participants don't understand it. They are simply playing games in ways that are beyond their understanding and which will ultimately be disastrous. At this point, the most likely outcome for us all is a general world depression, far worse than what we experienced in the 1930s. And if you recall, that one brought us a world war and the loss of 100 million lives. And except at the end, we didn't have nuclear weapons for that war. Now we do. The losses could be far, far worse. This could literally bring the end of civilization. And there's probably now no way to avoid it. No matter who we elect, no matter what policies they might adopt. And none of them are willing to come out and say so. Now, what then are my proposals for? If we can't prevent disaster and perhaps the fall of civilization, what good are all of my proposals? Well, the answer is that they are primarily for the time of picking up the pieces of civilization after the collapse. That doesn't mean we shouldn't propose them now. That doesn't mean we shouldn't start now working hard to try to get them adopted. Because the more things that we can do now before things go tragically wrong, the greater the chance we have of not having the people in their ignorance turn to charismatic demagogues who will lead them into war or worse, into slavery, because they cannot offer real solutions. We have to have solutions that are well on their way to being adopted and implemented. And then, when collapse occurs, we can build further on that and perhaps carry them to completion. it's going to be a very rough several decades. The 21st century is likely to be remembered as a dark age. But if we work together, we can make it an interlude toward a brighter age to follow. And I challenge everyone watching this to join me in my efforts to do that. I won't be around to see the end of it, and probably neither will most of you. This is for our grandchildren, our great-grandchildren, for generations to come. We need to sacrifice as our forefathers did, as the soldiers at Valley Forge, who suffered cold and hunger and misery and despair, and yet remained there, willing to fight and to die for a dream they had of a better future for their posterity. With the same blood that ran through their veins runs through ours, we can do no less.
Gee, John, after that, I think I just need a knife. Slit my throat and end the misery.
I was
do
a
that.
history major, and I agree with everything you said, but, you know, as you said, I think you're a little bit dark, because we do come up with a solution. There's some smart people in the world.
He's got a whole bunch of solutions. I'm Bill.
Hi, Bill. Ione McGinty.
Hi, Ione. How are you? I didn't know for sure if you were coming.
Yeah, nice to meet you. And this is my friend, Christy Hood. And
Hey, Christy. How are you?
She's a little lightning rod, and she has a website, JudgeRickOffSucks.com.
And I got to tell him in court that 100,000 people saw it, and it was on the record, and he recused himself the next day.
Did he? Oh, good. So that's the way we can get them all
Yes.
recused. It's,
Yeah,
good
I
size for all.
have a whole bunch of stuff to show you after
All
Ione
right.
tells her story.
Well, let me ask John a couple more things, and then John, I can interview
Do you mind if I
you
sit
for-
down?
No, help yourself. You just make yourself at home. You know I could interview you for a week.
Yes,
And there's
I've been told that often.
Yeah, or a month or whatever. But since we don't have time, I want to do some more with you, but I'll do it through live stream where I can capture it. You'll be at home, I'll be at
Sure.
my place. Let me ask you to comment on were you in the military?
Yes, Air Force.
Do you think our military has been sold a bill of goods on the fact that those who believe that they're fighting for justice? You want to comment on that?
Well, that's a complicated situation. A lot of the guys who are becoming active in militia here in Texas and elsewhere in the country are recent veterans. So they tell about what's going on in the military today. And they would be better ones to ask that question. In general, a few are aware, the numbers of aware are growing, but they are largely inarticulate, and the vast majority of the military is as clueless as the general population. The one benefit of military service, and it was a benefit for me, is a chance to see government from the inside and to learn how it can go wrong. And if you stay in a while, especially at the officer rank, in an officer rank, you don't get it so much as an enlisted man. You can get a lot of insight into the internal politics of government, because the military is a microcosm of government as a whole. You can see the empire building, the corruption, There wasn't that much of it in the Air Force when I was there, but there certainly was in the Army, and to a lesser extent in the Navy at the time. And I was stationed on an Army base. Very enlightening experience. We should not count on the military coming to our rescue. We'll get a few of them. We won't get as many as we would like. And so we need to peel off as many as we can to join us. It's part of our recruiting efforts. We need to recruit everywhere we can. But we should not expect too much.
Did you always know that it was this way, or was there a wake-up call for you at some point? How did you come to the realization that we don't have justice and the Constitution has been forsaken? Were you that smart
You want to turn it
in
on?
school? Yeah.
My career as a constitutionalist actually began in my senior year of high school. Now, I had been studying the Constitution since I think the first time I read it I was about 6 years old, and was immediately taken by it. It's this wonderful embodiment of wisdom. In my senior year of high school, the school principal violated the student constitution, and but nobody could find a copy of the Constitution. It was obvious it was so obvious a violation that you didn't have to read it to know it was a violation. So I dug up a copy of it. It was a Constitution he had written himself and filed away in a drawer, and it was pathetic. Well, in Texas, there is a law that requires student government, that requires student newspapers, and establishes standards for how these things are to be organized and conducted. And in particular, it requires a student constitution. So I set out to draft a student constitution that would meet the standards for such a document. And I did. I researched it. Found a book on the subject, laid it all out, drafted it, and the principal and the superintendent hit the fan. He admitted he didn't even read it. The mere thought that a student could propose a constitution was grounds for them to take oppressive action against us. That was my introduction to oppressive government. One by one, they peeled off our student supporters by threatening them, by threatening their coaches, by threatening their parents who were teachers in the system, by threatening them with bad letters of recommendation, and so forth. It was finally down to only 3 of us remained. I couldn't get action through the school board, so I went to the newspapers and wrote a series of articles that appeared in one of our local newspapers that started the dominoes falling. It took a while. The dominoes didn't stop falling while I was still in public school, but eventually they did, and reform occurred. I never forgot that lesson. I continued to study. Even in high school, I'd encountered a textbook with an important key passage which said that most of the legislation now being adopted would not have been, under the Commerce Clause, would not have been considered constitutional by the founders. Right in the textbook. I said, whoa. I started paying attention, started going through the Constitution to find all the ways it was being violated. And I found a lot. Then the time came to go into business, family business. It was real estate investment. That brought us into contact with the law. Started to have cases. I found that to win my cases, I needed to do most of the legal work myself. From real estate law to every other area of law, I began building upon my knowledge of the law. That book that I originally found on how to organize student government was in a law library in San Antonio, Texas, where I spent a lot of time hanging out reading law books. But I never actually tried to make an organized effort until the Davidian massacre, and as it would happen, work took me back to San Antonio to work in a building that overlooked the federal courthouse and in which the legal teams for both the prosecution and defense rented space to conduct their business. And I proceeded to observe the trial and also to make contact with temporary staffers working for both legal teams to have them feed me copies of the legal pleadings. So I got the judge's instructions to the jury before both lawyers or the jury got them. And I could see what was going on. So I made a vow to myself. Tragedy can happen in the field of battle. People can do evil things. But the court has to be a place where wrongs are righted. I made a list of all the ways that judicial and prosecutorial misconduct could occur. And I'd say if too many of these violations occur, it's going to be time to take action and start a new organized effort. The judge, the prosecutor, checked off every one of my items and came up with a few new ones I hadn't thought about. For me, that was the straw that broke the camel's back. I said, we're not going to get justice in the courts. We're going to have to organize a mass movement. So I did two things. I organized the Constitution Society, and I issued a nationwide call-up for a militia to muster everywhere early on the morning of April the 19th, 1994, including one in San Antonio that I led myself. The militias did muster. That was the beginning of the modern militia movement as a national public movement. Needless to say, the powers that be went ballistic. They had never anticipated the emergence of an armed resistance. They had contemplated armed resistance from individuals, but not from a mass movement. And all of a sudden, everything changed. Nobody had to fire a shot. The mere existence of an organized militia movement changed everything. And that was mated with the Constitution Society, which when I set up its website, suddenly became the place to go for everything having to do with the Constitution. Not just the U.S. Constitution, state constitutions, constitutions of other nations. other countries, even new countries, have even asked me to put their new constitutions on my websites because they didn't have a server to put it on. East Timor was an example of that. It preempted the field. I put content on that site that no one else had, not on a government site, not on a university site, nobody had it. And it quickly shot to the top of the search engine rankings and has remained there ever since. Hundreds of thousands of page views every day and growing, currently at a rate of about 20% per year. So this provides us hope. People are reading this material. I can see which pages they read, and the stuff they're reading offers hope that people are learning this material and gaining awareness and perhaps the foundations that on which action can be built. But now, of course, we need to translate all of this awareness into specific proposals and advance those proposals. We need to be bombarding members of Congress with demands that they introduce this legislation. And it needs to be the same legislation, not just nebulous demands to do something, leaving it then to figure out how to do it. They don't know how to do it. We actually have to draft the legislation, and I've started to do that. It's all there, already written, ready to be dropped in the hopper. And it's like any other legislation, it's going to require a mass movement to support it all the way through to adoption. And that's probably going to also mean the replacement of most members of Congress, the president, the judges, and so forth. We can measure our progress by the number of officials that we have to replace. Every time we replace an official with a better one, and we have to have the better ones lined up, that's a step forward toward the ultimate objective. And eventually, if we keep at it long enough, hard enough, smart enough, we are going to reach our goal.
Do you want to say we want our country back, or is it just too late? If you do, look right straight at the camera
No,
and say
I
it.
wouldn't put it in those terms.
How would you put it? Say whatever you want, directly in the camera, please.
This is our country. It's not their country. They work for us, not we for them. If we don't want to be slaves, we have to assert our rights. Rights do not defend themselves. The Constitution does not defend itself. You can't just write and adopt a document, whether it be a constitution or a statute, and expect it to be self-enforcing. It's not a machine that runs of itself. We have to make it work. We have to push the cart. We can't expect some magical horses to draw it for us. We are the horses, and we have to make every spoke of the wheel turn as we proceed toward the ultimate goal of victory.
We're going to start in just a minute. I got one or two more questions. We'll
Okay.
just be
Can I
running-
ask him a question?
Sure.
I mean, just off camera, just for a second. One of the things I'm trying to do is get an action committee together to pay for an attorney to go all the way up to the Supreme Court if necessary, to get the state commission on judicial conduct to not keep their findings on reprimands to the judges secret. Right now, newspapers can't get it. No one can get it. The only way even anyone knows if they're reprimanded is the person that files the reprimand puts it in there, which I have. And I'm getting some people together to do that, okay? And so I would like your card so I could send you what I've got, because that's step number one. The government's supposed to be transparent. If you've got judges have 20 complaints against them, but they're all secret and nobody knows, that's wrong. Judges are elected officials, and that we should know if they're not doing their job properly.
Yeah, you might also want to consider trying to get a friendly legislator to amend the Open Records Act to include those records under the Open Records Act. It's
Well,
now
they
ex-
tried recently.
It's now
Ione has a
excluded.
story. Yeah.
Yeah,
They're secret. They're secret. I mean, I've got it in the newspaper and everything, but only because I gave them, not because the judge. And this particular judge has over 20 complaints against him, 12 in the last 2 years, and it's all secret.
now I'll tell you the story once about how the judge kept secret the transcription of testimony in a case as a favor to the litigant who lied, basically, and has admitted his criminal activity on the witness stand, foolishly. The judge kept the transcript in a filing cabinet in his office.
It wasn't Rickoff, was it?
Well, I found out about that through a friendly clerk. And I found out from the friendly clerk when the judge was going to go out for an extended lunch. So I went into the judge's office, into the filing cabinet, pulled out the transcript, took it downstairs, got certified copies made, and put it back. Time came for my own case. Well, it was not a case, it was a hearing before the Texas Board of Banking Commission, because they were applying for a bank charter, and I was opposing it. I laid the certified copy of the transcript and introduced it as evidence. They didn't get their blank charter.
I bet they didn't. Yeah,
That's
I'm
the
sorry.
kind of thing you sometimes have to do.
Let me stop both of you.
I
I've gotta get a
apologize.
couple
I'm gonna
That's all right, no.
I'm shutting up.
I've got to get a couple things on before we leave. John, my voice isn't heard, so incorporate my question into your answer, if you will. There are a bunch of folks running around who say we're actually under admiralty law, that everything is we can't put our names in capital letters because it means we're a corporation, and America is actually all the courts are private corporations and all this blah blah. Can you put an end to that once and for all? What's the true story?
One of the problems we have is with what I sometimes call patriot mythmongers, who come up with often bizarre ideas for, legal theories about what's going on, what this is, what that is, almost all of which are intended to distract earnest patriots from pursuing constructive actions or paths of reform. And very often asking them to pay for this nonsense. Now, I won't recite here what some of that nonsense is. You can find plenty of examples of it discussed on my various websites. The important thing to understand is that if you find some bright, shining idea that seems to be a good one, being perpetrated usually by some uneducated layperson, first look to see whether that idea is supported on any of my websites. If it's not, it's probably nonsense. I could use a stronger word, but I won't on camera. I suspect that most of this is part of a controlled opposition. That most of these patriot mythmongers are in fact working for the opposition. And one of the reasons why I suspect this is because I once sat in a diner where government agents were gathered, where they typically had lunch, and overhearing them laughing and joking about how they were instigating this kind of thing. It's remarkable how candid these people can be in a public place when they think that nobody on the next table is listening. But I do listen. And I've learned a lot that way. There are favorite spots in Washington, D.C. where you can learn a lot about your government. It's just by sitting next to the right table. And from that, I have gotten a very strong picture that most of these patriot myths are in fact invented by and pushed by our opponents. You have to learn to recognize them and not pay attention to them. If it is simple and obvious and attractive, it's probably a bad idea. Now, that's not to say that the proposals I made don't have a certain elegance and attractiveness of their own, but they're generally not simple. They require intense study. You have to know something about the law to really understand them.
But John, I appreciate that. Do people lose in court because the judges are actually operating under a different set of laws that we don't know about?
No, people do not lose cases in court because the judges are proceeding under some alternative system of jurisprudence. Corruption does not have rules, except the rule of favoring one's cronies, those with whom one is connected. It is characterized not as an alternative rule of law, but as lawlessness. They make it up as they go along. No two such cases are really proceeding according to the same rules. That is what it means to have a rule of men instead of a rule of law. You cannot predict what arguments are going to work in a court that has no law. The only way that you can win is to be connected, or better connected than your adversaries. And if your adversary is the government, it's very difficult to be better connected than that. So forget all the notions that there is some magic insight that you can develop, that if you can only say just the right words, the magic words, that somehow the heavens will open and the angels will descend and bring you succor and deliver you from bondage. It doesn't work that way. The old favorite saying of lawyers is, a good lawyer knows the law, a great lawyer knows the judge. Now that doesn't just mean being his crony. It means knowing him psychologically, how to manipulate him, how to push his buttons. Winning a court case is a sales pitch by opposing salespeople. And as often as not, the deal is closed not on the basis of reason, but on the basis of emotion. You don't sell a house just because the numbers work, that it has a good investment. You sell a house because you build a dream. And people see themselves living in that dream. For the judge, the dream is a different kind of dream that you and I might want to dream. But it is a dream that he has come to accept and into which he is dedicated. It's a dream of comfortable, uncontroversial work and retirement and carousing with his buddies, doing their bidding. And until you can break that pattern, one of my reforms is to do away with the appointment and election of judges and replacing it with choosing judges the way jurors are chosen, at random, for limited periods of time, so they cannot become corrupted. Until we adopt such a system called sortition for judges and other officials, we are probably not going to be able to solve the problem. And my proposals include detailed ways by which that can be done.
John, if we were to succeed in taking control of our political system, what would be the best office for you? President, Chief Justice of the Supreme Court, Attorney General?
Probably on the Supreme Court, although I'm getting a little old for that.
You don't look that old.
Well, I don't feel that old either, except on bad days, but even if I didn't live very long, and the odds are high that I would be assassinated, I could probably do a lot of good in the time I had available. So it is not necessary for someone to be a lawyer or a judge to be on the Supreme Court. And it's time that we started putting people on the Supreme Court who are legal historians and legal philosophers, rather than just lawyers who have spent their careers milking the Constitution, cherry-picking it for ways to win their cases, instead of trying to really understand what was originally meant and understood by the framers.
Do you know about my proposal to form a new political party?
I know about it. I don't think we need another political party.
Okay, give me your comments.
We already have an alternative political party. In the years in which I've been involved with the Libertarian Party, we have converted it from a party, the focus of which is on policy, less government as policy, to one in which the focus is on constitutional compliance. That began essentially in about 2004. And ever since then, it has become primarily a party of constitutional compliance. Not everyone involved is a constitutional scholar, but many of us are. During the time in Texas, we have gone from getting 1% of the vote to about 3%. We can build on that. But people have to stop voting for the lesser of two evils and realize that their one vote is almost certainly not going to swing an election. What it can do is move public discourse. And if the Libertarian Party, composed of constitutionalists, can start getting enough votes, we can drive the other two parties toward a more libertarian constitutionalist position. That doesn't mean that the members of those parties are going to know what they're doing. We still ultimately have to replace most of them. But it's a start. It's laying a foundation on which other things can be built.
All right, that's a wrap.